Pam Vesilind will be speaking. She teaches animal law, food law, environmental law courses in both the VLS summer residential and our year-round distance learning program. Her scholarship is focused on the regulatory and constitutional issues at the intersection of industrial animal agriculture. She was previously on the full-time faculty here from 2009 to 2012, and also taught at the University of Arkansas School of Law from 2012 to 2014. She earned her BA degree from Guilford College, her JD degree from Vermont Law School, and her LLM in Food and Agricultural Law from the University of Arkansas School of Law. She is in her 6th continuous year of service in the summer program, teaching the law of animals and agriculture. And the exciting title of her Hot Topics lecture is Return to the Jungle, question mark.
Thank you. Thank you. Thank you, John. I think I'm in the 4th or 5th year of teaching this particular class, the Law of Animals and Agriculture. It's not a very exciting name. I might try to ratchet that up a little bit because I think the topic is riveting. And every year I tell my students, the tension's just getting tighter. This rubber band propeller is being wound tighter and tighter. And soon, very soon, there's going to be a real shift in our food regulatory system as it pertains to animals raised for food. And I think that, it's interesting, this time of year seems kind of sleepy and slow. I mean, yes, we are waiting for a few opinions, important opinions to come down from the Supreme Court, but we're generally, pretty relaxed in our summer classes. But right now there are actually several matters pending before the Supreme Court to get their decision about whether or not to actually issue, to see if the court will actually hear these cases. And we may actually find out sooner rather than later that we're going to get a Supreme Court opinion about this central question that is this class that I teach. And the central question is, who should regulate the treatment of animals while they're still alive that are raised for food for human consumption in this country? And when I say who, let's just take this from a federalism standpoint. Federal government or state government? Or should both parties regulate them? Or should there be no regulations? And by regulations, I'm talking about animal welfare issues. I'm not talking about food safety. I'm talking about things like conditions for them in confinement. Should there be standards for how they're confined, the space they're given, whether they're able to be outside, whether they, whether they should be in cages, or whether they should be treated with growth promotants so that they gain weight rapidly, which is another welfare issue. The transportation of the animals, how they're slaughtered, all of that. These are all questions that are, raised all along the supply chain before the animals are slaughtered. And the question of who should be regulating this is what is the source of this mounting tension. So let's just, because I like to put most things in sports terms, let's look at our two opposing sides. In this corner, we've got major industry leaders, and by that, animal agriculture. We've got Tyson, Pilgrim's Pride, and Sanderson, who all three own 50% of the chicken meat market in the United States. Tyson again, JBS, which is a subsidiary of a Brazilian beef corporation, and Smithfield, which is now owned by a Chinese company called the WH Group. They own about 54% of U.S. market share in pork. 6 of the top 66 egg producers in the country own 38% of the egg market, and the top egg producer is Cal-Maine. You may be familiar with it. Tyson again, JBS again. Cargill, and National Beef together have 75% of the beef market in this country. The top three have 64%. So they're in this corner. Along with them are the Department of Agriculture, and to a slightly lesser extent, the Food and Drug Administration. No secret, through years of regulatory capture, they have been somewhat neutered in terms of regulating the industry. Finally, Congress, which has also generally been absent from the question of the treatment of animals while they're still alive, although there are very broad federal laws having to do with food safety. If you're thinking that, wait, there are federal laws regulating animal welfare, I can think of Animal Welfare Act, Endangered Species Act, perhaps, Migratory Bird Act. Don't we regulate? Isn't there a federal criminal law having to do with dog fighting? Well, yes, that is true. There is one especially broad federal law called the Animal Welfare Act that does apply minimum care standards for many animals that are essentially traded in in commerce. This is zoos, laboratories, that chimpanzee on television, that kind of, those animals, there will be minimum care standards that the USDA, APHIS is supposed to enforce. But the definition of animal, the actual definition of the word animal in the Animal Welfare Act excludes farmed animals altogether. So there are no protections under the Animal Welfare Act. In fact, it's been 60 years since Congress has enacted any kind of meaningful legislation addressing the treatment of animals raised for food. And that last law was the 1958 Humane Methods of Slaughter Act. And that law actually only really applies to about 8% of the animals that are slaughtered for food in this country each year. The rest of them are poultry, and there are no humane slaughter standards for them. So it's safe to say that we really have very little in the way of federal regulations about how animals are treated when they're being raised for food. I haven't forgotten that we're doing corners. In the other corner, we've got the states. And actually, when I say states, I'm going to say the citizens of the states, because it's in states that actually have a voter initiative or ballot initiative system that a number of states have enacted laws that have phased out what have been identified as the most restrictive types of animal confinement. There are three. You may have even heard these terms: battery cages. This is the cages that in which egg-laying hens are in, either together or with several other hens or by themselves. They all have about this much room to themselves. The space allotted to them means that for their entire production life, they're in this cage and they aren't able to extend their wings or turn around, and it's an extraordinarily stressful experience. This is, we'll just call them battery cages for short. The idea is that these are birds that get no space, and actually so little space that after the first few months, they're kind of rubbed raw. It's a horrible existence, and it's not necessary for producing eggs. That's one of the production practices that a number of states have actually banned. And by that, I mean California, Massachusetts, Michigan, Ohio, and Oregon. Of that list, the only one that did not do this through a ballot initiative was Ohio. And that was because groups were circulating petitions to do this, to try and get this question of phasing out battery cages in Ohio. They were getting ready to, or they had already started circulating petitions to do this when the HSUS negotiated with the administration at the time to initiate these standards from a livestock board, regulatory let them do that on their own rather than have this be through a voter initiative. Okay, so the second of these two are gestation crates. This is from in the hog breeding. If you are not familiar with a gestation crate, or as the industry sometimes calls them, maternity pens, this is the about 7-foot by 2-foot cage in which a breeding sow, this the essentially where we get all of our hogs that become pork. In a breeding sow's life, they are artificially inseminated. They're in gestation crates for the term of their gestation. Essentially, just basically, I'm not being hyperbolic when I say they're just lying there. They can't move. They can't turn around. They are prone in this gestation crate. It is not necessary for hog breeding, and it's considered one of the top 3 most unnecessary or least necessary practice, and that is the one that actually the most states have actually banned. Arizona, California, Colorado, Florida, Massachusetts, Maine, Michigan, Ohio, Oregon, and Rhode Island. That's a fifth of the states in the country have banned gestation crates. That is not to say that Iowa and North Carolina have banned the use of gestation crates, and those happen to be the 2 states that, of course, produce the most hogs or pigs. So, of course, you have states that don't really have much invested in the hog production business that are banning this practice. Third one, very quickly, are veal crates. In the dairy production world, you've got to keep dairy cows breeding so that they will continue to lactate. Male calves born of dairy cows are an unnecessary byproduct of the dairy system. They are generally sent to be in the veal category of the animal industry. Either they'll be slaughtered very early on, or they'll go to a facility where they'll stay for another couple months tops before they are slaughtered for veal. There are some, there's still, pardon me, this is the practice that has been most phased out, but the most restrictive practice is the use of a veal crate, which sounds like what it is. It's just a really small confined area where the calf can't turn around again, can't move much, is kept completely, essentially, still so that they, confined so that they can't develop any muscle tone. Numerous states have also banned veal crates: Arizona, California, Colorado, Kentucky, Massachusetts, Maine, Michigan, Ohio, and Rhode Island. 9 states. California has also banned the production of foie gras. And my students will probably be quick to say no, actually. They've banned the sale and production of a product that is produced through force feeding with the intent of enlarging a bird's liver. I didn't get that exactly right, but right, they didn't ban foie gras altogether. They banned the forced feeding of birds. Okay, so their states are in this corner. Along with them, we've got what? Animal welfare groups, some food safety groups, but essentially it's the states themselves that are have really been pushing the envelope when it comes to raising standards and raising awareness for animals that are raised for food. So that could have gone on like that for a while, except for another law that California legislature enacted that kind of really ratcheted up the dispute or the tension between state and federal government. Think about it. You're the state of California, or let's say you're in the legislature. Your citizens in 2008 overwhelmingly supported Proposition 2. Proposition 2 banned all 3 of those things I just mentioned: veal crates, gestation crates, and battery cages, and said as of January 1st, 2015, that type of production is not going to happen in California. That's not us, right? This is how they are. massive animal cruelty code in that state. Well, as it happens, California also is a major egg-producing state. If you produce eggs, that's your livelihood, the first thing that you're going to be concerned about now is that you're going to have to spend money to convert your facilities to give the hens more room, whether you keep them in larger cages or you give them a cage-free environment. You're going to have to give them some room. That's going to cost you money. That's going to, obviously, that means you're going to have to charge more for your eggs. Well, what about this guy over here in Nevada? He's still using battery cages. He's happy to sell to Californians for a lower price. Also, these guys in Oklahoma, those guys in Missouri. So if you're a California egg producer, this ban is not good news, which is why, fortunately for them, the HSUS, the Humane Society of the U.S., worked along with the egg producers or the major representatives of the egg industry in California to draft a law that banned the sale of eggs produced using these confined battery cages in California. So, as of January 1st, no egg production was, as of January 1st of 2015, hens had to be given a certain amount of space in California, and no eggs could be sold in California unless the hens that laid that egg or those eggs had been given that amount of space. It doesn't matter where the eggs were laid. It doesn't matter where the operations were. Out of state, in state, who cares? And to California egg producers, that saved their livelihood. But it also meant that for consumers, they could be assured that eggs that they bought in California were going to conform to the standards that they supported at the ballot. Right? What's wrong with that? Well, if you're Missouri or Oklahoma or Nevada, you see plenty wrong with that. At the same, like I did mention that California also enacted a ban on force feeding of poultry birds for the purpose of enlarging their livers. They also banned the sale of food products that are derived through force feeding birds for the purpose of enlarging their livers. And when they enacted that law, they actually gave it a 7.5-year span of time before it took effect in hopes that the industry would come up with some way to produce foie gras that would not involve force-feeding birds. They didn't, and there was a lawsuit. And there was a lawsuit initiated against this egg sale ban that I just mentioned. And had that lawsuit been brought by the right plaintiff, we might have already kind of determined at least some answer to the question that I asked at the beginning, which was who should be regulating how we treat animals that we raise for food. Except that when major egg-producing states, including Missouri and Oklahoma, Nevada, Kentucky, objected to California's ban on the sale of eggs that didn't conform to their standards, they initiated the lawsuit together. The states banded together and initiated the lawsuit. Really the appropriate plaintiff in that case would have been a trade organization. Seriously, you guys, how many times has Vermont been sued by the Grocery Manufacturers Association? Or the Dairy, what's it called? Dairy Federation of America or something like that. Trade organizations are the perfect entity to sue on behalf of an industry. They get to be your face without giving you a bad name that you are promoting or wishing to preserve certain practices with your animals that you would rather not have associated with your name. But unfortunately, that really big trade organization was the United Egg Producers. And in 2012, when Congress was debating the last Farm Bill, we're back at it again now, but the last time Congress was debating, fighting over the terms of the Farm Bill, United Egg Producers was in full support and indeed promoting standards that would do the same thing that California and Massachusetts and Michigan, Ohio, et cetera, have done, which is give the laying hens more room. There was this proposal at the federal level in the last Farm Bill to mandate more room for laying hens. That would have been the first time in 60 years that we saw any kind of meaningful farmed animal welfare legislation. It failed. It actually got eliminated in reconciliation pretty much the last couple of days of negotiation. And you may remember the Farm Bill was almost a year late, or maybe a whole year late in being passed. Here we are again, talking about the Farm Bill again, but in the meantime, United Egg Producers had already come out in favor of phasing out battery cages, so UEP could not represent the egg producers. And so what happened in this challenge to California's sale ban was that the states of Missouri and Nevada and Oklahoma, et cetera, sued as the states, saying we challenge this California sale ban. And if you've had con law, you may have already, like, flags may have gone up in your head that this restriction that California has that says you can't sell your eggs in our state if they weren't produced to our standards for the birds, you might be thinking Dormant Commerce Clause, maybe. Perhaps you might, if you know something about food law, you might think that's federally preempted. Well, that's essentially what the plaintiffs claimed here in Missouri v. Harris. That's Pamela Harris. One of these days I'm going to figure out how to say her first name. And that case actually ended up getting dismissed for lack of standing because the judge, and then it was affirmed at the Ninth Circuit, said the states could not sue on behalf of a sector of their egg industry. So here we had this perfect chance to find some resolution, and it didn't happen. And since that time, we've had Massachusetts do something very similar to what California did in 2008. You may have heard this in 2016, just in that election. Massachusetts also had a ballot initiative. And this one was to ban to ban gestation crates, veal crates, and battery cages, same thing. But also, Massachusetts has now banned, and when it takes effect in 2022, the sale of eggs that are produced using eggs, just like California's egg sale ban, you have to conform to standards of space allotment for the laying hen to sell in California. And you have to show that if you want to sell veal in Massachusetts, you have to, it can only be sold there if the veal calf had a certain amount of space. When I say a certain amount of space, both the California and the Massachusetts laws really were very simple. They said the animal has to have enough room to turn around, lie down, extend their limbs. That was pretty much it. Leave the specifics as far as inches to the Department of Agriculture at the state level. But that's all that people were voting for. Pretty incremental, I would say anyway. So the third sale ban that Massachusetts voters enacted is the one that really is going to be a problem. And that is, it bans the sale of pork if it came from a breeding sow kept in a gestation crate, or pork that actually came from that breeding sow. That's an easier one to track. But imagine this. A breeding sow in a breeding establishment in North Carolina just is putting out piglets. The piglets maybe go to Iowa for the last part of their lives in the finishing stage, and then they're slaughtered. The pork goes any number of places. In order to sell in Massachusetts, you're going to have to show that at the very birthing stage, that facility used some method other than a gestation crate, that the breeding sow had enough room to stand up, lie down, turn around, and extend her arms and legs, right? Even if you don't know anything about food law, you got to be thinking, that sounds difficult to maybe track, right? How much are we actually tracking food at this point, or animal-derived foods? How do we really know where it comes from? Well, this could be pretty disruptive to our interstate commerce, potentially. And that is one of the two major claims that the states of Indiana, Alabama, Arkansas, Louisiana, Missouri again, Nebraska, North Dakota, Oklahoma, South Carolina, Texas, Utah, West Virginia, and Wisconsin all say these Massachusetts sale bans, you are essentially applying extraterritorial regulations. In other words, your Massachusetts law, you're trying to apply that in our state, and you can't do that. You're trying to change our industry, our way of doing things, just because this is what your voters want animals to be treated like, and you can't do that, right? So that is a question of interstate commerce law, or more specifically, more accurately, the dormant commerce clause doctrine. There's going to be this question of, if it's not a discriminatory law, this sale ban, is it balanced? Is the disruption that it causes interstate commerce balanced out by the weight of the state's interests? What are the state's interests in banning the sale of certain animal products that were produced using unnecessarily cruel methods? What are their interests? Perhaps food safety. That's one of the things that California and Massachusetts have gone to. But really what it comes down to is it's just straight up concern for the care of the animals. It's kind of ephemeral, right? Some people would say it's frivolous. But it's just, you know what? We just think it's just the right thing to do. Is that a legitimate state interest? Maybe. Because there have been cases in Dormant Commerce Clause history that a state has a legitimate interest in protecting certain natural resources in the form of animals even from just out-of-state citizens. And so this idea of protecting the environment, protecting animals in the environment, we're trying now to think about that as just protecting animals from being exploited in ways that we don't think are necessary. I'm not talking about making everybody vegan. We're just saying, do they really have to be in a crate that small? Can we not just give them a little more room? And that's going to be that balancing test, the Pike test of balancing the weight of how much does this sale ban in California and the sales bans in Massachusetts, how much are they disrupting interstate commerce? And is the interest of the citizens important enough to outweigh that, to essentially uphold the sales ban. Now, like I said, in Massachusetts, they're not going to take effect until January 1st, 2022. But that hasn't stopped the states that I just mentioned from already filing a bill of complaint to the Supreme Court. In December, both the states I just mentioned and most of the states that initially challenged the California egg sale ban, plus a few more states, got together and they filed two bills of complaint, two complaints and briefs in support in the Supreme Court as a matter of original jurisdiction, suing California. That doesn't happen very often. And most cases don't start in the Supreme Court, right? But when a state sues a state, if you think about Article 3, it does say that that is a matter of original jurisdiction. Is this issue one that is appropriate for the Supreme Court to hear it as a matter of first impression? We don't know yet. That's one of California's and Massachusetts' arguments against the case starting there. But in addition to this question of the Dormant Commerce Clause, which is, of course, very important, there's this other question of federal preemption. No, the federal government has said very little about animal welfare in food production, but it has said a lot about what happens to the carcass, to the eggs, to the milk, whatever, after the animal has been slaughtered, or even during that slaughter process. Federal law is firmly in that area. Inspections, regulations, standards, labeling, packaging, storage, you name it. And they're embodied in these laws that I'm sure you're familiar with, especially, if nothing else, the Food, Drug, and Cosmetic Act, which for the longest time, until literally like 3 weeks ago, I was calling the Food, Drug, and Cosmetics Act. And nobody corrected me. It's really embarrassing. But anyway, the Food, Drug, and Cosmetic Act does not apply to meat, poultry, or egg production. But there are complementary laws that are administered by the USDA called the Federal Meat Inspection Act, the Poultry Products Inspection Act, and the Egg Products Inspection Act. They are very similar in nature. They're big laws. They have, like I said, they regulate safety, inspection, all the stuff that goes on at the slaughterhouse and the processing plant, which is often the same, all of that. When you see USDA approved and it's got a letter or a grade A or something like that, that's all regulated. So, big laws. Big laws with a very big preemption clause. There's a section in each one of those four laws, that says that federal law expressly preempts states from enacting regulations within the scope of that law that are different than or in addition to facilities, premises, operations. Basically, states cannot enact a law that adds to or creates a different standard than what the federal standard is. I'm going somewhere here. That kind of makes sense when you think about it. Uniformity of food production is really necessary to being able to make sure that we have a reliable food supply at all times, and that the safety of the food is reliable. Before we had these federal laws, we had really the race to the bottom, that jungle that Upton Sinclair wrote about, where states had as low standards as possible in order to bring industry in, and slaughterhouses were a big part of that story. So we have these federal laws that prohibit that kind of race to the bottom or preempt because the federal government now sets these minimum standards for the safety and the handling of the products that are derived from animals. Now, what these laws don't do is regulate what happens when the animals are still alive at the hatchery or the breeding facility or at the nursery or the finishing lot or the feed lot or any of those stages while they're still alive. It does start to creep in when the animals reach the slaughterhouse. But before that, federal government doesn't have anything to say about what happens. I'm overgeneralizing, but for the most part, doesn't have much to say about what happens to these animals. Certainly not the care or the handling of them. What's considered abusive, what's considered appropriate or humane, if you will. But one of the arguments that these states are making to the Supreme Court is that these federal laws do preempt these states, California and Massachusetts, from enacting these production bans and the sales bans that support them. That you have to set that standard at the federal level. There's nothing wrong with a federal standard that we all kind of start with as a minimum. And that's how the Animal Welfare Act applies. That you have sort of minimum standards of care set by the federal government, and states can enact higher standards for those animals if they want to. They don't have to. But the way that these cases are starting to shake out, and the arguments that are being made, is that the federal government has not only the authority to regulate minimum standards of care for animals that we raise and slaughter for food, but also maximum. That the federal government gets exclusive authority over that. And that's unprecedented. Because when you think about it, state animal cruelty laws are one of the purest exercises of state police power we can think of. They tell us what we can and cannot do with our property, but they recognize that these are something more than just personal property. This is where the states, aside from farmed animal law, food law, states pretty much own that domain of seeing for the welfare of animals. So none of this really conforms to what we understand are traditional state authorities versus federal. I don't know what's going to happen. I'm a little nervous about it, honestly, because not only are these two cases before the Supreme Court, and I should say that in April, the court invited the Solicitor General to brief these two cases, which indicates to me that chances are pretty good they're going to want to hear it, or at least 4 of them are going to want to hear these cases. Not only that, but that foie gras ban, or the ban on the sale of products created from force-feeding poultry birds, that also went back up through the Ninth Circuit and has been appealed to the Supreme Court. And the court's going to consider that in conference this Thursday. Probably it will invite the Solicitor General to brief it, which means we'll now have 3 cases. And whatever happens, it's going to make a big difference in how we view and how we regulate the treatment of animals, the 9.4 billion animals that we slaughter for food in this country every year. And that's it. So I'm happy to take any questions if you have any.
We have a microphone for those who have questions.
Is it on? You mentioned earlier that there's a lack of transparency between the mother hog and then where the piglets get distributed. Could more enforcement in that supply chain management help to regulate that? And would that be, do you think, more on a federal level, state level, or within the industry?
So a lot of it that is intrastate regulated at the state level, that you have to have, have ways to identify the origin of and where they're going, of the animals when they're traveling in state, and when they cross state lines, the next state will likely want that information too. The ability to track that information is there, but that centralized kind of collection of data is not there. But it is certainly capable of being there. And there's this crazy law that was enacted after 9/11 called the Animal Health Protection Act. And even though it grants the USDA really, really broad authority to promulgate regulations that would do just this, could do this, it just hasn't, it's basically it was enacted to protect our food supply from being compromised or really bioterrorism concerns, and then nothing really came of it. But the federal authority is there to do what you're talking about.
Okay.
Professor.
Thank you. You discussed governmental advocacy at the federal and state level and corporate advocacy at the trade association individual level, but I don't think I heard you say much about citizen advocacy. And with the long history of the ASPCA, or the fact that major religions have major ethical codes for treatment of animals, I would have expected that there would be some advocacy supported on the citizen and religious group front, but I'm not aware of much. Can you help me?
So I don't know if you heard that, and maybe I didn't say this clearly, but nearly all of the states that have enacted certain restrictions on how or that those are initiated at the citizen level. Beyond that, consumer fraud claims, when you think something is labeled as humane, when you think it's not, that's a possibility. There's been plenty of pressure on the industry through retailers, big purchasers of food like McDonald's, Burger King, Wendy's, Walmart, Kroger. Those retailers have all been, as I'm sure you know, kind of jumping on this train that says we're going to start sourcing our pork and eggs and veal or whatever from producers that have higher welfare standards. Kind of aspirational because the market hasn't, the production hasn't changed yet. Still 95% of our eggs are still produced using this battery cage method in the United States. We're not there yet. But that the citizen part of it has really been very influential on the consumer, through the consumer's voice. So, and as far as litigation goes, yeah, there's challenging rulemaking challenges, NEPA challenges, things like that. But there's just not a lot of, because there isn't a lot of federal law, like there is an environmental law, there aren't really a lot of legal hooks there. Does that make sense?
What I'm hearing you say is there's a fair amount of potential.
I always think there's a lot of potential, but I don't. But I wouldn't say. I mean, I don't think that HSUS or ALDF are resting on their laurels. I mean, you'll see those names on environmental law cases, NEPA cases, consumer protection cases, food safety. They'll get involved in anything because that's their way into trying to affect some change into the treatment of the animals. But without any actual laws that deal with the treatment of the animals, they can't litigate in that area. But there's certainly potential for it.
I'm wondering if you could potentially talk a little bit more about the characterization of the state interest involved and whether there is any history of case law that suggests that pure moral interests might be sufficient to do the kind of things that these states want to do?
Yeah, we talk about this a lot in class, right? From an environmental standard, that I think is the greatest entry point. And I will be perfectly honest that I haven't researched this as thoroughly as I plan to, as far as trying to determine how exactly you build this case. But because there is a recognized legitimate state interest in this, and this is in case law up to the Supreme Court, that states and citizens and states have a legitimate interest in protecting animals from cruelty, that is, at least there is precedent recognizing that. I didn't mention this, but there are a couple states that also ban the slaughter of horses or the possession of horse meat that's been slaughtered for human consumption. And those have been upheld at the circuit level based on this idea that citizens have the authority to decide what animals they want to protect and which ones they don't. And so I truly don't know how weighty that ethical concern about animals is. But it helps that in both California and Massachusetts, I mean, Prop 2 in California passed by a greater percentage than any other proposition has. More people voted for that than supported Obama in '08. And even more supported the one in Massachusetts. I think that was like 73, 4%, something. It was insane. It's an easy thing to vote for, though, right? Yes, I like animals, right? But yeah, that's the big question. Because I think the Dormant Commerce Clause question is going to be the tougher one to fight, yeah.
So I'm just curious, what about more labeling? I see labels on egg cartons all the time, but I don't think I've ever seen labels on pork or veal, actually.
We just had a class on that today. There are third-party certification programs that that offer opportunities for companies to get certified or pronounce that they adhere to certain welfare standards, but they don't all offer the same thing, and in fact, one of them is really misleading. There's the organic label, the USDA organic label, that does not actually have much in the way of animal welfare in it, despite the fact that a lot of consumers think that it does. And in fact, last year this time at the Hot Topic, I talked about how after 10 years of negotiation, there was a final rule finally issued the last day of President Obama's administration that said, okay, we're going to start to do these minimum, we're going to deliver on these minimum care standards for animals that are raised for organic eggs or organic milk or meat. And of course, like many other regulations, that was withdrawn, delayed, then withdrawn altogether this past May. So that didn't happen. Beyond that, honestly, you could put something like humane on your label, on your pork. I don't know what that would mean to you, but it's not regulated. So it's kind of the Wild West right now.
Pam, I have a question for you over here,
Who is it?
hiding over here, about wildlife. But before I do, for the students in the room, just so you know, because we'll get emails out, but not sure during the summertime, we're going to have a couple of open house meetings on next year's curriculum in Hoff Lounge on Monday at noon and Thursday at 4:30 in the afternoon. So if people have, I'll be there, the dean, and Sean Nolan on curriculum. So my question for you is wildlife. Lots of parts of the country, wildlife plays an important role in either culturally or substantively providing protein needs. I'm just kind of wondering how that fits into this analysis.
Doesn't it all?
There we
That
go.
is
Thank you.
Thanks for your question. No, because the way that wild animals are regulated is just a totally different ballgame. So you've got, like our pets. at the state level, we regulate them, you know, your dog, you have these obligations to your dog, or legal duties to feed and you know, give them enough water, et cetera, and you aren't allowed to treat them in certain ways. So they're very protected. But wildlife animals are considered a natural resource. They're, you know, essentially, if not technically, in trust, managed by the state natural resources, as you say, for the enjoyment and benefit of all the citizens. So they're not regulated as a food product in the way that farm animals are. They're not owned by an individual the way farm animals are.
And with that, I think we have to let people go to class, starting at 1, and go on with the rest of their day otherwise. And thank you again,
you.
Pamela, for
Thanks.
a wonderful presentation.